on another matter.
This
To
is also
AMLAC.
for Senator Trillanes?
For AMLAC po.
For AMLA. AMLC?
Executive Director,
Yes, ma'am.
dun po sa mga submissions nyo sa committee, meron ho ba kayong sinubmit na document na confidential information sharing?
Sorry.
The confidential information sharing?
Yes, Madam Chair. There is. It's the one flashed earlier.
The confidential information sharing. Ito ho ba yung the document consisting of 15 pages
That is correct, Madam Chair.
and that the subjects of this confidential information sharing are subject number 1, Sara Zimmerman Duterte, and subject number 2, Attorney Manasseh Reyes Carpio.
That is correct, Madam Chair.
Can we ask you, Mr. Executive Director, to read
Please
for us?
speak closer to the microphone, Kong.
Can we ask you po to read for us paragraph 14 of that confidential information sharing under the caption derogatory records involving subject number 1, Sara Zimmerman Duterte? Can you please read for the record?
Based on records, derogatory records, number 14, VP Sara was the subject of suspicion in 27 confidential reports submitted by covered persons on 2 August 2024 to 29 January 2026, citing suspected activities involving drug trafficking and related offenses, graft and corrupt practices, and malversation of public funds and property. Drug trafficking and related offenses, so triggered in connection with the House Quad Committee hearing on former President Rodrigo Duterte's war on drugs, as well as by news reports alleging the involvement of VP Sara's husband in the 6.4 billion shabu importation in 2017. Graft and corrupt practices / malversation of public funds, there are in relation to news articles related to the impeachment case filed against VP Sara in 2025, as well as alleged misuse of confidential / intelligence funds.
Pwede po bang ma-flash din po yan sa screen?
Do we know what particular page is this?
Paragraph 14,
Page 6, Madam
page
Chair.
6 of 15.
Paragraph
14.
14,
Page
page
6.
6.
Yan po. Medyo hindi ho masyadong mabilis ho kasi masyado yung pagkakabasa kanina ni Executive Director. So I deemed it proper na ipakita po dyan. So that's derogatory records. At merong sinasabing suspected activities involving drug trafficking and related offenses, graft and corrupt practices, and malversation of public funds and property. So can we say that this is actually a product of the financial investigation? Pag nakalagay po, pag meron po kayong ganitong confidential information sharing, galing po saan ito?
This one is reported by the banks, by the covered persons, Madam Chair.
By the covered
By
bank
the covered
or banking
persons.
institution as reported to you?
Yes,
As
yes,
reported to
Madam Chair.
AMLC?
Yes, Madam Chair.
Can we also ask you to read for the record and also to be flashed on the screen, Madam Chair? Paragraph 36, page 15, or the last page of this document.
Paragraph 36, page 15.
Can we ask the Honorable Executive Director to also read for the record as it is flashed on the screen?
Derogatory records 36. Attorney Carpio was the subject of suspicion in 17 confidential reports submitted by covered persons on 14 September 2017 to 25 April 2025, citing suspected activities involving drug trafficking and related offenses and malversation of public funds and property. For drug trafficking and related offenses, triggered in connection with the news report on alleged involvement in the 6.4 billion shabu importation in 2017. Malversation of public funds, triggered by news articles in relation to his wife, VP Sara, alleged misuse of confidential/intelligence funds.
So, pinapakita po nito na meron pala kayo talagang nakuha o nailagay, na-report na derogatory records involving the two subjects of your confidential information sharing.
Based on records, yes, Madam Chair.
Thank you, Madam Chair.
Thank you. Is AMLA ready to answer the questions regarding transaction subject of confirmation? Whether or not the same appear in the AMLC report submitted to this committee. Are you ready? If you need more time, then we may proceed to other resource persons.
So,
Are you ready?
we are ready partially, Madam Chair, so we can at least...
Okay. Please mention first the amount
The
and
annex.
then whether it's part or not of your report.
Okay, for Annex H, Madam Chair, so to clarify, I am not confirming the report provided by, mentioned earlier because I am not privy whatever the source of that report. What I'm telling is there is a movement of funds on this particular date as reported to us, which is based on the covered transaction or suspicious transaction.
Can we flash again Annex? Is that Annex H?
Annex H, Madam
Annex
Chair.
H. To be responsive to the request of the Honorable De Lima, can you at least say whether that transaction is part of the report of AMLC? Kasama po ba itong transaction na ito sa report ng AMLC na sinumite dito sa Justice Committee?
Madam Chair, given that we are only given limited information, I cannot confirm, for example, what's the nature of the transfer, where is the addressee, and all. So
We,
what we can
we are
only-
not inquiring as to the nature of the transfer, just
No.
whether or not that amount appears as well in the report of the AMLC.
I can confirm, Madam Chair, if there is a movement of funds on that same date with the same amount involving the same
That
account.
will
Will
be
fine?
enough.
Yes.
Okay.
That will be
That's
enough.
okay. So for
Madam Chair, to be clarified, no? When you say, pag sinabi po ninyong movement, ibig sabihin, may deposito?
there's
Tama
a
po ba?
transaction. There's a transaction.
From one transaction to another.
Yes, Madam
So, ibig
Chair.
sabihin, may deposito na ganitong amount sa isang bangko, pumasok sa isang bangko. Tama po ba?
We'll have to verify if it is a fund transfer or fund out or deposit.
Nonetheless, please limit your answer to what appears already
Okay.
in the report.
Okay.
So, for the guidance of the members, I think that will be enough response to the query of the Honorable De Lima that on such date, there is similar transaction appearing in the AMLC report.
Yeah.
Let us be consistent to the nature of our proceeding that we are merely determining the existence of probable cause.
Thank you, Madam Chair.
Next,
So-
please.
For Annex H, can we show again?
Annex H, please flash.
So for December 9, 2014, on our records, based on our records, there is a transaction amounting to 16,852,832.94.
Confirm, Madam Chair.
So similar transaction appear in the AMLC report.
Yes, Madam Chair.
Next.
For March 28, 2014, there is a transaction amounting to 41,721,035 pesos, 0.62.
In other words, it's confirmed. Similar transaction appear in the AMLC report. Next.
For May 19, 2010, there is a transaction that we saw in the amount of pesos 563.86.
Confirm similar transaction appear in the AMLC report.
On February 4, 2010, there is a transaction amounting to 10,374,307.49.
Confirmed again, similar transaction appear in the report.
Can we get the last in Annex H? The last one we were unable, in page 10, we were unable to capture.
Kindly state the last transaction in Annex H, Honorable De Lima.
10,374,370
We have confirmed that
307.49 at page 12.
in page 10, Madam Chair,
Page 10.
the transaction in page 10. Wala.
Page 10, that's March 3, 2011,
Alright.
in
So,
the amount of 1,750,617.84.
so we inform that there is a transaction on our records dated March 3, 2011 in the amount of 1,750,617.84.
Confirmed.
Confirm similar transaction appear in AMLC report.
Then for can we ask the last one, the one involving 1 million pesos, the particular date, Madam Chair?
Page 9, 1 million, dated March 28, 2011. Ay, 1 million? Yes. March 28, 2011.
We confirm, rather, we inform that there is a transaction in the amount of 1 million on March 28, 2011.
Confirmed as well, similar transaction appear in the AMLC report. That's a total of how many transactions, Honorable De Lima?
It's supposed to be 5.
Total of
Maybe
5 transactions for Annex H, all confirmed by the AMLC. Similar transactions appear in the AMLC report. Are you ready for the next annex?
Yes, Annex I.
Annex I.
That's the one from Samuel Uy, Sami Uy.
Please flash Annex I.
We inform that based on our records, there is a transaction in the amount of 7,440,846.07 on March 17, 2011.
Confirmed.
For the first transaction, confirm. Similar transaction appear in the AMLC report.
We inform that on October 25, 2011, there is a transaction in the amount of 7,440,846.07.
Likewise, confirm for the second transaction. Similar transaction appear in AMLC report. Third,
On April 24, 2012, we inform that there's a transaction in the amount of 7,440,846.07.
the third transaction is likewise confirmed. Similar transaction appear in the AMLC report. So, this total of 3 transactions appearing in Annex I with the title Sami Uy Payouts to Sara Duterte and Family, all of this were confirmed by the AMLC that similar transactions appear in their report.
Madam Chair, point of clarification.
Honorable DS J.J. Suarez.
Tama po ba ang pagkaunawa ko na ito pong kinukumpirma ng AMLC ay yung mga lumabas sa sinumpaang salaysay ng ating dating Senador Sonny Trillanes?
That is correct.
So ito po yung mga ilan sa mga bank records na binabanggit. Ngayon po, at nakakailang banggit na po tayo na lumalabas ay tama.
At least similar transactions exist in
Randomly
the
selected.
AMLC report.
These are randomly selected
Yes.
entries. or
Transactions were randomly selected by the Honorable Dilima, and she requested the confirmation of the AMLC whether or not similar transactions appear. And so far, 8 transactions have been confirmed already by the AMLC.
Maraming salamat po,
8
Madam
out
Chair,
of
for the
8.
clarification.
Are you ready to continue, AMLC?
Yes, Madam Chair.
Okay,
for
what annex is that?
Annex B.
Please flash Annex B. First transaction.
So we inform that there is a similar transaction based on our records on June 11, 2015 in the amount of 2,450,000 pesos.
Confirm similar transaction appear in the AMLC report. Next.
We inform that on December 6, 2013, there is a transaction in the amount of 2,987,542.24.
Confirmed as well. Similar transaction appear in the report.
We confirm that on January 31, 2012, there is a transaction in the amount of 2,926,594.60.
Confirmed again. Similar transaction appear.
We inform that on May 19, 2010, there is a transaction in the amount of 2,001,563.86 pesos. Centavos.
Third transaction is confirmed.
We inform that there is a transaction on May 14, 2008 in the amount of 2,114,168.43.
Confirmed again. Appearing in the report.
So that's the fifth one po, Madam Chair.
That's
So
the
the
fifth.
last for
So
Annex
far we
B.
have 13 out of 13 transactions randomly selected by the Honorable Dilima, but confirmed to be existing at least as similar transactions in the AMLC report. Ready to continue, AMLC?
Madam Chair, may we ask the Congressman De Lima if we can get again the accounts in Annex A? We were not able to jot down.
Annex A.
yes po. Also, these are also 5 transactions. Number 9, page 1 of Annex A. 55,131,747.32, March 28, 2014. Got it po? The second one po, number 16, page 1, 41,721,035.62, October 7, 2013. Third, randomly selected entry at page 3, number 44, page 3, amount of 53,817,613.48, February 25, 2010. Fourth, at page 4, number 60, amount of 52,485,191.85, April 14, 2009. And the fifth one, also at page 4, number 64, 49,281,009.98, May 22, 2007. 5 randomly selected entries from Annex A, joint account of Rodrigo Duterte and Sara Duterte.
Do you need more time? Ready to answer?
Yes, Madam Chair.
You may proceed.
We confirm that for all the dates and amounts mentioned, there are similar transactions existing in the AMLC report.
Okay. What annex is this again?
Annex A.
So 5 out of 5 transactions randomly selected by Honorable De Lima from Annex A is confirmed by the AMLC, at least that similar transactions appear in their report. Are there any other subject of confirmations? No more.
Marami po kasi ito, that's why I just randomly selected 5 from each of the annexes.
So in total, how many transactions have been confirmed?
There are 4 annexes, so 5 times 4, 20,
Plus 3.
plus 3.
So total of 23 transactions were subject matter of request for confirmation.
Kasama na po doon yung 3, yung sa
Yes.
Sami Uy. So 20.
23 out
20.
of 23.
Oh, 18.
18.
Sorry po,
We just
18 because Annex A, Annex B, Annex H, and Annex I. So 4, 3 times 5, 1 is only 3. So 18.
Do you confirm that? Total of 18 transactions?
We informed earlier that there are 18 transactions mentioned that
Okay.
that one we mentioned are existing in our report.
So
based on
for
our
the
report
record, 18 out of 18 transactions randomly selected from the annexes of Sinumpang Salaysay of Honorable Trillanes were confirmed by the AMLC, at least to the extent that similar transactions appear in their report. That is for the record. Honorable De Lima, do you have further clarificatory questions?
Just a manifestation, Madam Chair. So nakita po natin na na-confirm po ng AMLAC yung mga entries na randomly selected from the annexes. At gusto ko rin i-put on record po, Madam Chair, na actually marami po ito. But that's it, because of lack of time, I just opted to ask for 5 from the 3 annexes and 3 from the other annex. Pero marami po. Sa Annex A po, there are a total of 71 entries. Annex B, Annex A, by the way, is Rodrigo Duterte, Sara Duterte bank transactions. Annex B, which is the Sara Duterte Manscarpio bank transactions, a total of 47. Annex H, the master list, the data, the main record, the master, the table of all already of the accounts here would be a total of, wala ho palang nakalagay na mga number kung ilan lahat, but this is medyo numerous po ito. And sa Annex A ho, sa Annex I, which is the Samuel Sami Uy payout to Sara Duterte and family, there are a total of 20 entries. So marami po sila na mga transactions. So that is all for me, because this is just a clarificatory questions. I just wanted that, those clarified, particularly the confirmation. Very significant po yung pag-confirm nung lahat na randomly selected na entries.
Thank you, Honorable De Lima. Any other member who wishes to raise clarificatory questions? The Honorable Abante and then the Honorable Sendanya.
Thank you, Madam Chair. Senator Trillanes,
Closer to the microphone, please.
nabasa ko po yung salaysay ninyo at nahilo ako sa dami ng zero sa mga halagang binabanggit ninyo. Kaya gusto ko pong linawin natin para sa kaalaman ng mga ordinaryong Pilipino na napakarami po ang nakikinig at nanonood po ngayon. No? Mr. Senator, binanggit po ninyo sa paragraph 23 at 24 na si Vice President Sara Duterte at ang kanyang pamilya ay tumanggap ng daang-daang milyong piso mula kay Samuel Sami Uy. Tama ho ito, hindi ho ba?
Yes, Your Honor.
O naniniwala din po kayo na ito pong mga milyong-milyong pisong ito dahil lang po sa ang nagbigay po niya na isa Sami Uy, galing po yan sa droga.
That part of the affidavit of the Honorable Trillanes?
Yes.
Yes, Your Honor.
Okay, you may proceed.
Yes, Your Honor.
Okay. Nakalagay po dito sa number 35 ng inyong salaysay ang mga transaksyong pinansyal ni Sara Duterte at ng mga malapit na miyembro ng kanyang pamilya na nag-uugnay sa kanya kay Sami Uy at sa mga tinukoy na personalidad na sangkot sa droga o drug personalities ay lubhang nakababahala. Hindi lamang dahil ito ay malinaw na paglabag sa konstitusyon at sa iba't ibang batas ng bansa, kundi malinaw din itong naglalagay ng malalim na pagdududa sa kanyang personal na integridad at kakayahan o moral capacity upang patuloy na magsilbi bilang pangalawang Pangulo ng Pilipinas. Ito po ay nabanggit po ninyo na malinaw.
Yes, Your Honor.
Oo. Now, ang sabi rin po dito, sinabi rin po ninyo na may mga payouts nakalagay na pumasok po sa bank account ni VP Sara na nagkakahalaga ng mahigit 22 million mula kay Sami Uy. Tama ho ba yun?
Yes, Your Honor. At ito lang po yung nakita namin na nakapangalan sa kanya na manager's checks. Pero pag titignan po natin doon sa Annex A na isinumite, yung mga pumasok po na malalaking mga deposito ay tumutugma din dito sa March or April tapos October. So, ang conclusion ko po dito ay nung una, cheque ang ibinibigay, pero kinalaunan, mga bank transfers na. Kaya yun po ang personal conclusion ko based dun sa mga movements na nakita namin sa bangko. Pero ito po, maliwanag kasi manager's check po ito na nakapangalan po sa kanila, mga miyembro ng pamilya.
Ito po naman, Madam Chair, Senator, no? Hindi lamang droga, kundi nabanggit po ninyo sa number 25, si Sami Uy ay isang kilalang political contributor ni Rodrigo Duterte at kilalang kasama o kasosyo ni Michael Yang, ang dating economic advisor ni Duterte na siya namang iniuugnay sa mga kontrobersya ng family at pogo. Gayon din sa bilyong-bilyong halaga ng mga illegal na droga na nakumpiska sa isang bodega sa Pogo Compound sa Porac, Pampanga. Ito po yung nasabi nyo, di ba?
Yes, Your Honor.
Therefore, pinapaniwalaan nyo rin po ba na hindi lang droga, kundi pogo rin?
I believe
sa Radyo Bombo!
I-check ang smoke detector sa inyo balay o kung establishmento kabombo. Hindi pagpabayaan ang kalayo nga wala sang bantay.
Limpyo nga palibot, luwas nga kabuhi sa balatian. Reduce, reuse, recycle. Kag hindi magaboy sang basura bisan diin. Mangin responsable, protektahi ang palibot kag kinaiyahan. Mangin responsable sa paghimos sang imo nga basura. Pagproteher sa environment, unahon ta.
Nga panahon sang social media, isa lang ka-click, pwede ka makabulig, pero pwede ka man makapakalain. Amo ina nga importante, untaton ang cyberbullying. Madamo subong nga kabataan kag bisan mga tigulang ang nagagamit sang online platform para makapang-insulto, magpangaway, makaguba sang isig kapareho, makaguba sang relasyon, pahuyan ang iban, kag madamo pa nga paagi nga madako nga epekto sa kabuhi sang mga biktima. Gani, dapat nga antes kita mag-post, antes mag-comment, antes mag-share, huna-hunaa, anay. Kung hindi makabulig, hindi na pag-ipadayon. Kung makasakit, hindi na pag-itype. Kung hindi sigurado, kag base hindi matuod, hindi pag-i-share. Kung ikaw man ang biktima, hindi magpabaya. Report ang nagabuli sa imo, i-block, magpangayo bulig sa pamilya, abyan, kag otoridad. Hindi mo kinanglan antuson ang cyberbullying. Bangod may lahi kita nga magpahatang sang penalidad sa ila. Ipalapnag ang respeto, tindugan ang kabuhi, untaton ang cyberbullying.
Ang hindi nga pahinumdom ang ginadulong sa inyo sang Bombo Radyo Coronadal. Basta Radyo, Bombo!
Kabombo! Patyang suga kung wala na ini ginagamit. Huksa ang appliances kung hindi na kinahanglan. Tipigi ang kuryente. Tipigi ang imo nga kwarta. Kag buligi ang kalibutan. Magkinot sa tanan nga tion. Conserve energy, subong kag sa palabuton kabombo.
Ang standby mode sang inyo computers kag gadgets nagakonsumo gihapon sang kuryente. I-shutdown na sing husto kag bunuton ang saksakan kon tapos na ang obra o kon hampang. Kon pwede lang gamita ang laptop kaysa desktop computer. Mas energy efficient ang laptop kag mas gamay ang kuryente nga kinahanglanon sini.
Ang kada bata deserve magtuon kag maghampang. Hindi sila pagpaobraha, protektahi ang ila mga katungod kag katagi sila sang masanag nga palaabuton. Kay ang kabataan amo ang paglaom sang aton buwas. Buligay kita sa pagpanalipod sa ila.
Sa nga barato, ginarekomendar ang pag-switch ang LED bulbs. Mas masanag, mas matawhay, kag mas gamay ang konsumo sa kurente. Kumparar sa ordinaryo nga bombilya, masanag nga hindi masakit sa busa, gani magiwais kag mag-LED bulbs na.
Bombo, handa bala ka mo sa katalagman? Emergency kit at ni-prepare na.
Sa dahig at sa ilan pang mga resource person natin na mga may kabatiran dito ho sa takbo ng kaso ng former president. Mamaya ay kukuha rin tayo ng mga update kaugnay naman ng nagpapatuloy na impeachment proceedings dyan sa bahagi ng Kamara de Representantes kung saan ay ilang personalidad ang humarap bilang resource person kaugnay naman ng mga reklamo laban sa Vice President na si Sara Duterte. Alamin din natin mamaya mga kaganapan dyan naman sa mataas na kapulungan ng Kongreso kaugnay dun sa kanilang mga pagpupulong at ilang mga aktibidad kaugnay dun sa sinasabi na mga paghahanda na kaugnay sa posible na maging takbo ng impeachment proceedings kapag ito ho ay nagtapos na dyan sa Kamara de Representantes. At live nationwide via satellite, ito na mga kabombo ang ating mga balita na tampok sa oras na ito. Pagdedesisyonan na ngayong Abril 22 mga kabombo ng Appeals Chamber ng International Criminal Court kung may jurisdiction ito sa kaso ng umano'y killings o yung mga pagpatay dito sa Pilipinas na may kaugnayan sa war on drugs. lalo na ng nakalipas na Duterte administration. Ang magiging desisyon ng International Criminal Court ang siyang magtatakda ng direksyon ukol sa kaso laban kay dating Pangulong Rodrigo Duterte kung papanigan ng korte na may jurisdiction ito. Posibleng magtuloy-tuloy ang proseso patungo naman sa trial stage kung sakaling baligtarin ang naunang desisyon. Maaari hong mapatigil ang kaso kung makikita naman ito ng sapat na rason. Hiwalay pa rito mga kabombo at mga ka-Star Nation ang inaasahang desisyon sa katapusan ng Abril kung saan may sapat na batayan para ituloy ang paglilitis o hindi. At ito ay uusad naman sa full trial ng naturang kaso kaya nakadepende pa rin sa magiging kapasyahan ng mga maestrado ng International Criminal Court. Ang dalawang magkasunod na pasya mga kabombo ang itinuturing na kritikal sa magiging kinabukasan ng mga kaso sa ilalim ng International Criminal Court proceedings. Sa ilalim ng proseso mga kabombo at mga ka-Star Nation ng International Criminal Court, ang confirmation of charges ay hakbang para tukuyin kung may sapat nga bang ebidensya na magpapatunay na may substantial grounds to believe na nagawa ng akusado o inaakusahang individual ang mga krimen na isinampal laban sa kanya. Kapag nakumpirma ang mga kaso, buuman o bahagi lamang ay ililipat ang usapin sa trial chamber para naman sa aktual na paglilitis. Ayon sa patakaran ng korte, ilalabas ng pre-trial chamber ang desisyon nito sa loob ng 60 araw at ito nga ay magtatapos sa darating na 30 ng Abril. Pre-trial chamber 1 mga kabombo ang siyang humahawak nito kaya naman narito ang mga huwes na siyang pinangalanan upang humawak ng naturang usapin. Ang nakikita natin dito sa bahaging kaliwa ng ating screen doon sa mga nanonood via Facebook Live at YouTube Live ng Bombo Radio Philippines. Ito ho si Judge Yulia Motok, ang siyang presiding judge ng naturan hong lupon. Si Judge Rene Alapini Ganzo ang nasa gitna at Judge Socorro Flores Lera ang nasa kabilang bahagi naman dito sa may bandang kanan. Samantala, yung Office of the Prosecutors naman ay kinabibilangan ho ito ng mga personalidad na tinutukoy ng International Criminal Court, pinangungunahan ni Ma'am May Mandaye Nyang, ang Deputy Prosecutor, mga kabombo at mga ka-Star Nation. At nagkaroon ng ilang mga pagbabago dyan, bunsod na rin ng kinakaharap na usapin ng dating namumuno sa panigo ng prosekusyon. Samantala sa defense team mga kabombo at mga ka-Star Nation, ipinapakita natin sa screen si Nicholas Kaufman, siya ang lead defense counsel ng former president at nariyan din si Dov Jacobs, associate counsel naman ng panig ng depensa. May hiwalay ding kinatawan para naman sa mga biktima na bahagi ng proseso na nagbibigay ng kanilang mga pananaw para sa kaso habang umuusad ang pagdinig dyan pa rin sa International Criminal Court. At ilan ho sa kanila ay susubukan nating makausap maya lamang kaugnay pa rin ng mga usapin may kinalaman sa mga kaganapan dyan sa International Criminal Court. At muling nanawagan mga kabombo ang grupong mga grupo na nakatutok dito, partikular yung hakbang ng maisog na palayain itong si dating Pangulong Rodrigo Duterte mula sa detention dyan sa International Criminal Court. At iginigit nila na nilalabag daw ng international body ang due process at yung mga karapatan ng former president. Ayon sa grupo, arbitrary ang pagkakaaresto kay former President Duterte at tinawag itong gross violation ng kanyang mga karapatan. Kini-question din mga kabombo ang jurisdiksyon ng International Criminal Court dito sa Pilipinas matapos ang pag-withdraw na ng ating bansa sa Rome Statute noon pang 2019. Lumalabas mga kabombo, mga ka-Star Nation, na ang kanilang argumento ay kaugnay doon sa pagiging bahagi pa rin ng Pilipinas noong 2018 bago naging epektibo itong pagkalas ng taong 2019. At ngayon ay ganap ng naging epektibo yung naturang pagkalas sa Rome Statute, ngunit ito ay kinakailangan pa rin ayon sa mga eksperto na dinggin ang kasong kinakaharap ni former President Duterte dahil nangyari ang mga inaakusa sa kanya sa panahon na miyembro pa ang Pilipinas ng Rome Statute. Inigit din ng grupo na dapat ibalik itong si Duterte sa bansa dahil daw sa edad nito at sa usapin ng kanyang kalusugan. At bago tayo umusad mga kabombo, mga ka-Star Nation, sa iba pang mga update, kunin muna natin ang masasabi rito ng isa ho sa mga counsel mula sa panig ng mga biktima ng extrajudicial killing. So yung panahon po ng war on drugs campaign ng former President Rodrigo Duterte. Nasa linya ng ating komunikasyon si Attorney Nery Colmenares. Pagbati muna po sa ating mga taga-subaybay, nga taga-panood at taga-pakinig ng Bombo Radio Philippines. We are nationwide and worldwide. By the way, si Bombo Dennis Hamito po ito. Welcome to the program, Attorney Nery.
Hi, Bombo Dennis, at magandang araw din sa lahat ng nakikinig at nanonood sa programa natin dyan sa Bombo Radio.
Unang-una, ano ho yung mga kaganapan sa panig ng mga biktima, sapagkat last time I heard meron pong viewing para ho dun sa mga biktima, lalo na yung hindi nakapunta dun sa The Hague. How about ngayong araw po, ano po ang mga aktibidad ng inyo pong panig, and baka gusto po ninyong mabanggit na rin ang mga ini-expect dito ho sa proceedings dyan sa International Criminal Court?
Well, yes, nandito kami ngayon. May Justice Watch dito, ang mga pamilya, mga abogado, at maraming media rin dito. Dito sa UP, no, kasi mabuti pinagbigyan kami na dito i-hold yung Justice Watch, kumbaga na manonood kami sa desisyon ng korte ng ICC ngayong alas 5 ng hapon. So we're hoping of course na paborable sa mga biktima, paborable sa hustisya at sa accountability ang desisyon ng ICC.
Okay, si former President Rodrigo Duterte ay nag-waive na ng kanyang appearance dito ho sa paglalabas ng pasya kaugnay ho dun sa jurisdiction. By the way, Attorney Nery, ano ho ang tawag dito? Sapagkat dito sa Pilipinas, pag maglalabas ng desisyon, parang promulgation of case. Pero ito kasi parang ito ay sa usapin ng jurisdiction. So kumbaga part ito ng main case. Pero hindi pa ito talaga yung pinakang pinag-uusapan talaga dito.
Yes.
Kumbaga, jurisdiction pa lamang. So ano po yung tawag dito para sa kabatiran ng mga non-lawyers, attorney?
Well, kasi ngayon nasa pre-trial stage pa lang, no? Tagal nga Bombo Dennis 2016, 2017 pa na patay yung mga kaanak ng biktima. 2026 na ngayon tapos wala pang trial dahil sa daming motion ni President Duterte na pang-delay. Baliktad nga normally pag nakakulong ka, you claim your right to speedy trial. Ito sa kanya, baliktad dinidelay niya ng dinidelay. So pre-trial ito. Pag trial na mismo at may promulgation ng decision, kung sakaling humantong sa trial, dapat nandun siya. Pero ang ngayon, he can waive his presence sa trial dito sa decision na ito, at karapatan niya yon sa ilalim ng Rome Statute, no, na pwede siyang mag-waive ng presence niya. Ngayon lang, dismayado ang mga biktima na bakit ayaw niyang harapin. Parang, alam niyo, trademark ata ng Duterte yung absentee at avoidance Kasi hindi rin siya uma-appear doon sa ICC. Dito naman, hindi rin uma-appear si Vice President sa impeachment proceedings. So, mukhang ayaw talaga nilang humarap, at ang gamit nilang dahilan, ba't hindi sila nag-appear? Yung usual na ginagamit ng mga politikong may kaso dito, politically motivated ang proceeding. So, in any case, nandiyan na tayo. At of course, they have the right not to appear. Yun nga lang, mas gusto sana namin makita na humarap sila sa mga kaso nila.
I heard from your end, Attorney Neri, na hindi na talaga kayo tumuloy ngayon doon sa The Hague, because of some issues.
Wala kaming pamasahe. Sa sahig lang kami, Bombo Dennis. Hindi kami naka-raise ng hindi kami naka-raise ng pondo. Pero siguro pag manalo kami dito at magkaroon na ng trial, baka maka-raise kami ng mga donasyon mula sa mga supporters ng hustisya, supporters ng mga kaanak na mag-contribute para sa pamasahe kung sakali matuloy ang trial.
Okay, Attorney Neri, we're just concerned of course about yung mismo pagdating po sa full trial. Uubligahin po ba? Papaano kung aayaw ang panig ho nitong si former President Duterte at hindi nila kikilalanin ang jurisdiction like yung ilalabas ho ngayon, jurisdiction. But of course, ang kanilang stand ay hindi nila kinikilala. So ano ho ang kahihinat na nito, Attorney Neri?
Saan? Palabas? Dito lang. Yes. Well, of course, karapatan niya nga. Pero pag trial, i-insist na namin na umattend siya. Magharapan naman sila ng mga kaanak ng biktima para makita ang kanyang makita ang mata na, makita niya rin ang mga kaanak ng mga biniktima niya. So, hopefully, ma-present na siya.
Okay. Final point, Attorney Neri, dahil alam ko may mga activities pa rin po kayo. Mga gaano ho ang itatagal nito proceedings ngayong araw na ito, 22 ng Abril?
Well, basahin nila ang decision, so hindi naman ganun katagal yun. Siguro naman mahaba na yung 1 oras. Depende sa kung gaano kahaba ang pag-explain nila ng decision nila. So, kung 5 p.m. magsimula, siguro mga before 6 tapos na ito. Kaya dito sa Justice Watch viewing namin, sana naman masaya mamaya ang ending nito at magkaroon naman ng programa after the decision. Kung saan magpaliwanag ang mga abogado at ang mga biktima rin ng kanilang mga pagtingin sa decision ng Korte.
I see. Okay. Muli po kami makikipag-ugnayan siguro after nitong mga development po na ito para man sa mga update dahil gusto ring marinig ng mga nasa Visayas, Mindanao, lalo na dun sa malalayo pang lugar yung mga update from your end and of course dyan sa International Criminal Court. Thank you so much.
Maraming salamat, Bombo Dennis. Magandang araw sa inyo.
Kabombo, mga ka-Star Nation, nakausap po natin ang isa sa mga abogado ng mga biktima ng War on Drugs campaign, si Attorney Neri Colmenares, Victims Council at kabilang ho siya doon sa mga dumalo doon sa The Hague sa mga nakalipas po na pagkakataon. But of course, ngayon ay hindi ho sila natuloy dahil doon sa binabanggit ho niya kanina, nabigo sila na makapag-raise ng sapat na pondo para ho matuloy yung kanilang biyahe. Lalo na ho ngayon, medyo tumaas ho yung airfare, yung pagbili ng ticket sa mga eroplano, lalo na ito international travel, itong mga kabombo, mga ka-Star Nation. But of course, ay sinusubukan din po natin at this point na makontak yung panig naman po o kampo ng mga Duterte, yung mga supporters ng former president para naman makapagbigay din sila ng kanilang panig. Samantala, maliban ho dito sa ating tinutugay-gayang kaganapan sa International Criminal Court, kukuha rin tayo ng mga update mula ho dyan sa Kamara de Representantes, kaugnay ho dun sa mga development naman ho dun dahil kanina ay may mga humarap, mga personalidad para ho magbigay ng kanilang testimonya. So maya-maya ho yan, mga kabombo at mga ka-Star Nation. Tuloy pa tayo sa ating mga balita. Naglabas ho ng kautusan ng Korte Suprema na nag-uutos dito ho sa bahagi ng Palasyo Malacanang. Ito mga kabombo at mga ka-Star Nation ay may kinalaman dun sa usapin ng hinihingi na drug test para kay President Ferdinand Bongbong Marcos Jr. Dito ay pinagkukomento sa loob ng 10 araw ang Palasyo Malacanang. Partikular ho ang kampo nitong si Pangulong Marcos para naman sa kahilingan ng dating House Speaker na si Pantaleon Bebot Alvarez. Ang naturang petisyon mga kabombo ay humihiling na obligahin ang Pangulong Ferdinand Bongbong Marcos Jr. na sumailalim sa physical at mental test, no? At kabilang ho dyan yung hair follicle test. At ito ay bahagi ng paraan ng drug test na hinihingi po sa kanya. Yung sa health issues ay una na ho itong pinabulaanan ng Palasyo Malacanang ang usapin na patay na ang Pangulo dahil ito ho yung mga unang lumabas na impormasyon mula sa ilang mga individual na ngayon ay hinahanap na ng National Bureau of Investigation upang panagutin. Sinasabi kasi na malubha ang karamdaman ng Pangulong Marcos at nakaratay habang sa ibang impormasyon ay sinasabi pa ng ilan na pumanaw na ang Chief Executive. Bagay na mariing pinabulaanan ng Palasyo Malacanang at inilabas nga si Pangulong Marcos na tumatalon-talon, nag-jumping jack at nagbibigay ng talumpati at nakipaghabulan pa sa mga kagawad ng media. Kasama ho sa kahilingan ng petisyon na idinulog dyan sa Korte Suprema ang direktiba na ilabas daw at ipahayag sa publiko ang isang medical report na naglalaman ng resulta ng pagsusuri kabilang na ang clinical test at yung kumpirmasyon ng kanyang physical at mental health o yung kanyang mental status upang gampanan ang kapasidad bilang isang Pangulo. Binigyan ng 10 araw nga na hindi na maaring palawigin pa ang mga respondent para naman sa oras ng pagtanggap ng abiso ay dito na magsisimula ang pagbilang ng 10 araw. Ang hakbang na ito mga kabombo ng Korte Suprema ay nagbubukas naman sa mas malalim pa na usapin hinggil sa transparency at accountability ng pinakamataas na opisyal ng bansa, lalo na sa gitna ng mga panawagan para naman sa mas malinaw na pagtitiyak sa kalusugan at kakayahan ng Pangulo na pamunuan ang ating bansa. Susubukan natin mga kabombo, mga update naman dyan sa Kamara de Representantes hinggil doon sa isinagawa kanina na mga pagharap ng ilang mga individual. In fact, nariyan yung pinuno ng Office of the Ombudsman. Maya-maya ho yan mga kabombo at mga ka-Star Nation. Samantala, sinabi ni Senate President Pro Tempore Panfilo Ping Lacson na dapat dumalo si dating House Speaker Ferdinand Martin Romualdez sa mga pagdinig ng Senate Blue Ribbon Committee na naitakda noon pong nakalipas na taon pa at hindi ho sumipot ang former House Speaker sa mga aligasyon laban sa kanya kaugnay ng umano'y katiwalian sa 2025 national budget. Partikular na ang pondo na nakalaan sa mga proyekto ukol sa flood control ng projects ng gobyerno. Ayon nga kay Lacson, nagpadala ang kanilang lupon ng hindi bababa sa 2 imbitasyon para kay Romualdez na dumaan sa tanggapan ni Speaker Faustino Boji III alinsunod na rin sa prinsipyo ng interparliamentary courtesy upang tumugon sa mga paratang na nag-uugnay sa kanya sa kontrobersyal na flood control projects. At pati ng iba pang mga anomalya na kakibat ho ng naturang usapin, lalo na yung may kinalaman sa katiwalian sa pondo ng taong bayan. Ngunit hindi ho sumipot ang dating pinuno ng Kamara de Representantes at maliban ho dyan ay hindi rin ito nagsalita sa mga nakalipas na buwan. Pero itong nakalipas na araw ay nagbigay ho ito ng kanyang mga pahayag sa pamamagitan ng video message. Itong Martes ay naglabas nga siya ng video statement na kung saan ay mariin niyang itinatanggi ang pagkakasangkot doon sa usapin ng 2025 budget at yung flood control scandal. Itinuturo pa niya sina dating Senate President Francis Chis Escudero at former Representative Elizalde Co na umano'y bahagi ng Bicameral Conference Committee na gumawa ng mga pagbabago sa General Appropriations Bill matapos itong maaprubahan ng Senado at ng Kamara. Sa ngayon ay wala pang itinakdang araw kung kailan ang susunod na pagdinig ng Blue Ribbon Panel hinggil naman sa investigasyon ng umano'y anomalya sa flood control projects. Ngunit kung matatandaan, nauna nang sinabi ni Senator Lacson na pansamantala munang ipinagpaliban ang kanilang mga pagdinig hanggat hindi pa kumpleto ang pirma ng partial committee report at ito ay ipipresenta sa plenaryo ng mataas na kapulungan ng Kongreso. Samantala, sa mga karagdagan nating balita, mga kabombo at mga ka-Star Nation, habang tayo ho ay nag-aantabay dun ho sa mga development dyan sa Kamara de Representantes, inaasahang papabor daw dito sa usapin ng mga kaso ni former President Rodrigo Duterte dyan sa Appeals Chamber ng International Criminal Court sa mga naunang desisyon ng pre-trial chamber na kinikilala ang jurisdiksyon ng korte sa mga kasong may kinalaman sa war on drugs campaign dito sa Pilipinas. Ayon yan kay International Criminal Court accredited lawyer Attorney Cristina Conti. Sa isang pahayag nga ay sinabi ni Conti na malinaw na may jurisdiksyon ng International Criminal Court sa naturang kaso at kung sakali man na baligtarin ito ay magiging self-defeating ang buong proseso sa paglilitis na magtatagal ng mas mahaba pang panahon sa kanilang mga isinasagawang aktibidad. Ayon pa sa kanya, ang kasalukuyang yugto ay isa ng appeal stage kung saan ay may umiiral na desisyon mula naman sa pre-trial chamber na inilabas noon pang Oktubre. Bagamat wala pang ginagawang public hearing ay ipinalabas at ipinaliwanag na ng International Criminal Court ang kanilang pasya na nagsasabing may jurisdiksyon ang korte sa naturang kaso. Sa puntong ito mga kabombo at mga ka-Star Nation, ang katanungan ngayon ay para sa appeal sa chamber ay kung tama ba na naging pasya nila para sa pre-trial chamber na may jurisdiksyon batay doon sa mga umiiral na batayan ng kanilang panig. Ang sasabihin anya ng appeals chamber ay walang sapat na dahilan para naman baligtarin ang naturang desisyon. Ang appeals chamber mga kabombo at mga ka-Star Nation ng International Criminal Court ang inaasahan na maglalabas ng pinal na pasya para sa usapin ng jurisdiksyon na isang mahalagang issue na nagpapatuloy pa rin na investigasyon kaugnay ng aligasyon ng crime against humanity na may kaugnayan sa kampanya kontra sa illegal na droga ng nakaraang administrasyon. Sa ngayon ay hinihintay pa ang magiging desisyon ng hukuman na maaaring magtakda ng direksyon para sa kaso sa mga susunod na hakbang ng international panel kaugnay doon sa mga paglilitis, mga kabombo at mga ka-Star Nation. Antabay din tayo mga kabombo at makakausap natin maya-maya si Attorney 𝐀𝐏𝐑𝐈𝐋 Cortez, ang presidente ng National Union of People's Lawyer, para ho dito sa mga update at kung ano yung kanilang mga expectation mga kabombo at mga ka-Star Nation. At sa pagkakataong ito, oras natin sa buong kapuluan ay meron na lamang ho tayong nalalabing 3 minuto bago sumapit ang alas 5 ng hapon at sa linya ng ating komunikasyon ay nariyan na si Attorney 𝐀𝐏𝐹 Cortez. Magandang hapon po sa inyo. Si Bombo Dennis Hamito po ito at live po tayo ngayon sa Bombo Radio Philippines. Napapakinggan at napapanood po tayo through digital channels ng Bombo Radio Philippines. Welcome to the program, Attorney.
Ang fearless forecast ko ay i-affirm ng pre-trial ng appeal chamber ang desisyon ng pre-trial chamber na merong jurisdiction ng ICC over dun sa case against President Duterte. Ito yung aking fearless forecast. At may mga basis ako dyan. Unang-una, ang mga acts involved dito sa case ni Duterte were committed at the time that the Philippines was still a member of the ICC. Secondly, yung investigation was commenced in February of 2008. Yung preliminary examination was commenced in February 2018 by the Office of the Prosecutor. At ito yung nag-signal, nagsimula na yung proceedings. At dito titignan kung kailan nagsimula ang paglilitis kay Duterte ng criminal court. So hindi ito nagsimula noong June noong 2021 nung panahon na nag-authorize ang pre-trial chamber na mag-continue na ng preliminary investigation ng prosecutor. Kasi sa tingin natin, yung preliminary examination ay part ng isang single proceeding at nai-initiate ito through an examination na ang purpose ay to determine whether may na-commit na crimes against humanity. Ibig sabihin, nandun lahat yung gravity, whether widespread, whether systematic, i-determine nila yon. And ang purpose is to determine whether to initiate a formal investigation. So, nung inauthorize ng pre-trial chamber ang Office of the Prosecutor to conduct the preliminary investigation, ay nagkaroon lang ng progression ang proceedings from examination to a formal investigation through the preliminary investigation. Na ang purpose na dito ay to zero in on who are to be held accountable for the acts ng crimes against humanity that was determined na may nangyari nga sa Pilipinas. So, when you try to determine when did the jurisdiction of the ICC attach, nag-assume sila ng jurisdiction in February 2018 when the Office of the Prosecutor started the preliminary examination. At hindi noong 2021 start ang preliminary investigation. We have to consider the fact that isang court lang yung ICC composed of the prosecutor and the different chambers, and at the same time there is one single proceedings in the investigation commencing from the examination until makapunta sa trial. Ang position ko, and considering nga na the acts were committed at the time.
Yun. With that, maraming salamat po, Attorney Cortez. Babalikan ko po yung linya nyo maya-maya lamang sapagkat I think nagsimula na ho yung development dyan sa International Criminal Court. Mga kabombo at mga ka-Star Nation, ating pakinggan at panoorin ang mga kaganapan sa International Criminal Court sa The Hague.
Luz del Carmen Ibáñez Carranza, presiding in this appeal against arising from the case of Mr. Rodrigo Roa Duterte. My fellow judges in this appeal are Judge Tomoko Akane, Judge Solomi Balungi Bota, Judge 𝐀𝐏𝐑𝐈𝐋, and Judge Erdene Balsuren Damde. I will allow now the parties and participants to identify themselves. First, the defense, please. You have the floor.
Good morning, Your Honours. As you're aware, the former President, Rodrigo Duterte, has been excused appearance today. The defence is represented by myself, Attorney 𝐀𝐏𝐑𝐈𝐋, Dr. Dov Jacobs, Attorney Davide Rancati, Maître Alexandre Dezev-Davy, Attorney 𝐀𝐏𝐑𝐈𝐋, and Nicholas Russo.
Thank you. Now, please, the Office of the Prosecutor. Please, you have the floor.
Good morning, Your Honours. The Office of the Prosecution is represented by Matthew Cross, Appeals Counsel, Edward Jeremy, Trial Lawyer, and myself, Mary Chey-Regué, Appeals Counsel.
Thank you. Finally, the Office of the Public Counsel for Victims, please.
Good morning, Madam President, Your Honours. The Common Legal Representative Team for a Participating Victim is composed today by Mr. Joel Butuyan, Counsel, Mr. Orcholon Naransetsek, Legal Officer, Ms. Ann Grabowski, Legal Officer, and myself, Paulina Masida.
Thank you. I take it that the attendees are the same as the ones appearing on the list which the court officer kindly provided to the appeals chamber before the hearing. If the composition of any of the teams has changed, please notify the court officer by email. I note for the record that Mr. Duterte is not present in the courtroom as he has waived his right to be present and the appeals chamber has authorized it. His written waiver has been filed on the record. He is represented by his counsel. Today, the appeals chamber will deliver its judgment in the appeal of Mr. Duterte against the pretrial's first decision of the 23rd October 2025, entitled Decision on the Defense Challenge to the Jurisdiction of the Court, which I will refer hereinafter as to the impugned decision. In that decision, which bears the document number 309 in the case record, the pretrial chamber found that the court can exercise its jurisdiction in the present case over the crimes alleged against Mr. Duterte that were committed on the territory of the Republic of Philippines while it was a state party. This is a non-authoritative summary of the appeals chamber's written judgment in the appeal. The authoritative version is the written judgment, which will be made available and notified after this hearing. Background of the appeal. I will start with a brief background to this appeal. As I have already mentioned, the pretrial chamber issued the impugned decision on the 23rd October 2025. On 14 November 2025, the defense submitted its appeal brief raising 4 grounds of appeal and requesting the appeals chamber to reverse the impugned decision, to find that there exists no legal basis for the continuation of the International Criminal Court's proceedings against Mr. Duterte, and order his immediate and unconditional release. On 8 December 2025, the prosecutor and the OPCV responded to the appeal brief requesting the appeals chamber to confirm the impugned decision. Upon invitation from the appeals chamber, the prosecutor and the OPCV filed on 16th January 2026 additional observations on various issues considered necessary for the proper disposal of the appeal, and the defense filed a response thereto on the 23rd January 2026. The appeals chamber's judgment. I shall proceed to outline the decision of the appeals chamber on the merits of the appeal. First ground of appeal. Under its first ground of appeal, the defense contends that the pretrial chamber erred in finding that Article 127(2) is lex specialis with respect to Article 12. The appeals chamber recalls that the impugned decision, the pretrial chamber considered the effects of the withdrawal of the Philippines from the statute in circumstances in which the pretrial chamber granted the authorization to proceed with an investigation pursuant to Article 15(3) after the withdrawal had become effective. It concluded that Articles 12(2) and 13(c), which I will refer to hereafter as provisions in Part 2, read in isolation, would not support the court's jurisdiction in the present case. However, in the interpretation of the pretrial chamber, Article 127(2) operates as lex specialis applicable to circumstances of a state party's withdrawal from the statute, with the effect that the court retains jurisdiction in the present case. The appeals chamber considers it important to determine the scope and meaning of these provisions, pursuant to Articles 31 to 33 of the Vienna Convention on the Law of Treaties, which require, inter alia, that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. The appeals chamber notes the wording of the heading of Article 12 addressing the preconditions of the exercise of jurisdiction. Within those preconditions, Article 12.2 stipulates that the court may exercise its jurisdiction if one or more of the following states, i.e., the state on the territory of which the conduct in question occurred, or the state of which the person accused of the crimes is nationals, are parties to this statute. The appeal chamber particularly underlines that this article uses the present tense, which implies that a contemporaneous assessment is required. The appeals chamber rejects the argument of the prosecutor that the use of the present tense may plausibly reflect drafting convenience or even oversight, rather than the introduction of a restriction on the court's exercise of jurisdiction. The appeals chamber observes that during the discussion leading up to the Rome Conference, the adoption of Article 12 proved to be perhaps the most difficult compromise in the entire negotiations. Therefore, it cannot be assumed that this language, which is repeatedly and interconnectedly employed in Part 2 of the statute, can be easily dismissed as accidental. Rather, this wording lends support to the interpretation that the relevant states must be parties to the statute at the time the court exercises its jurisdiction. Articles 11 to 15, all referring to the exercise of the court's jurisdiction, are interconnected and must be subject to a systemic reading. Pursuant Article 12.1, there is a point in time at which a state becomes a party to the statute and accordingly accepts the jurisdiction of the court with respect to the crimes listed in Article 5. From this point in time, jurisdiction exists with respect to the relevant state until the acceptance is revoked by a state party's withdrawal from the statute. However, according to the statutory framework, the existence of jurisdiction needs to be distinguished from the exercise of jurisdiction. In situations of a state party's withdrawal from the statute, these provisions must also be assessed in light of Article 127, which addresses specific circumstances and determines that the withdrawal shall not prejudice in any way the continued consideration of any matter which was already under consideration by the court prior to the date on which the withdrawal became effective. The Appeals Chamber observes that the provisions referred to above must also be interpreted in line with the object and purpose of the statute, which is to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole, and thus to contribute to the prevention of such crimes. It would be incompatible with this object and purpose to enable a state party to evade its responsibilities under the statute by depositing a written notice of withdrawal once it discovers that alleged crimes committed on its territory or by its nationals are being examined by the prosecution. At the same time, the state's right to withdraw from the statute would not be effective if the court were able to exercise jurisdiction indefinitely, despite the state no longer being a party. The present interpretation ensures an appropriate balance between the ability of states to effectively withdraw from the statute and the responsibilities that states accept upon ratification of the statute. whilst providing a clear timeline within which the examinations must be pursued. The appeals chamber now turns to the contention of the defense under the first ground of appeal, namely that the pretrial chamber erred in law by construing Article 127.2 as lex specialis vis-à-vis Articles 12.2 and 13c. In situations involving a state party's withdrawal from the statute, these provisions must be assessed systemically in light of Article 127, which specifically addresses the consequences of such a withdrawal. The appeals chamber notes that the defense argues mainly in abstract and theoretical terms, focusing on the principle of lex specialis. However, the key issue in this appeal is not how the principle is classified or applied in theory, but whether the pretrial chamber made a legal error in interpreting the statute. For this reason, the appeals chamber finds it unnecessary to address the defense's arguments on the scope and application of lex specialis, as they do not affect the outcome of this appeal. The appeals chamber considers that what is determinative to this appeal is whether the pretrial chamber incurred an error of law in its interpretation of the statute. In the view of the appeals chamber, the provisions in Part 2, read together with Article 127.2, settle the legal regime applicable to situations of a state party withdrawal. Accordingly, the appeals chamber finds no error in the pretrial chamber's interpretation of Article 12.2, as requiring that the relevant state be party to the statute at the time the court exercises its jurisdiction, read together with Article 127, which establishes when the withdrawal takes effect and the regime applicable under these circumstances. For the aforementioned reasons, the appeals chamber unanimously rejects the defense's first ground of appeal. I shall now turn to the second ground of appeal. Under the second ground of appeal, the defense argues that the pretrial chamber erred in finding that a preliminary examination may qualify as a matter under the consideration of the court within the meaning of Article 127.2. The appeals chamber rejects this argument of appeal by majority. Judge 𝐀𝐏𝐑𝐈𝐋 dissents on this point. His reasons are set out in detail in his dissenting opinion. Therefore, my references hereafter to the appeals chamber shall be understood in light of this qualification, meaning that the relevant findings pertain to the majority of the appeals chamber, as Judge 𝐀𝐏𝐑𝐈𝐋 is partially dissenting. Under its second ground of appeal, the defense raises 4 subgrounds of appeal. First, the defense contends that the pretrial chamber adopted an overly broad interpretation of the term matter under Article 127.2 and failed to give due weight to other language versions of the statute in interpreting this provision. Having examined the arguments raised by the parties and participants, the appeals chamber finds that the pretrial chamber properly assessed the ordinary meaning of the words any matter under consideration, and did not expand them to include a mere concern or thought. Moreover, it did not espouse a particular reference for the English version of the statute. Rather, in accordance with the test set out in the Vienna Convention on the Law of Treaties, it embraced the interpretation that best reconciles any difference of wording in the texts in favor of a broad reading of the phrase any matter. Therefore, the appeals chamber does not discern any error in this respect. Second, the defense alleged that the pretrial chamber erred in law by finding that a preliminary examination renders a matter under the consideration of the court within the meaning of Article 127(2). Having analyzed all submissions received, the appeals chamber also rejects this argument. The appeals chamber observes that the preliminary examination phase has a clear basis in the court's legal texts, including in Articles 15 and 53 of the statute and Rules 46 to 48 of the Rules of Procedure and Evidence. In addition, the specific preliminary examination carried out in the Philippines situation properly qualifies as any matter which was already under the consideration of the court for the purposes of Article 127(2). The appeal chamber notes that in the specific circumstances as detailed in the impugned decision, the prosecutor, A, decided to initiate a preliminary examination prior to the Philippines' withdrawal from the statute, B, publicly announced the initiation of a preliminary examination, C, adopted a number of procedural steps, some of which involved judicial rulings, and D, submitted a request to initiate a proprio motu investigation on the basis of the results of the preliminary examination. As a result, the appeals chamber dismisses this argument. Third, the defense argues that the pretrial chamber's application of the concept of subsequent practice in relation to the Philippines' continued engagement with the court after its withdrawal was legally inappropriate and factually incorrect. The appeals chamber recalls inter alia that in the context of its request to defer the prosecutor's investigation under Article 18(2), the Philippines underlined that the court lacks jurisdiction over the Philippines situation. The appeals chamber is of the view that the Philippines' decision to arrest and surrender Mr. Duterte, as well as its further engagement with the court, is insufficient to support a conclusion that the practice of the Philippines following its withdrawal qualifies as subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation within the meaning of Article 21(3)(b of the Vienna Convention